And welcome everybody to the 19th edition of the Deserve to Win podcast. As always, I'm your host, Eric J. Troutman, the czar of the TCPA, the czar of just about everything these days. Really excited for today. I'm going to actually jump to the guest before I even introduce my wonderful co-host. Andrew Perrong. You can't spell Perrong without wrong. Will be joining us today as our special guest. Believe me, you are definitely going to want to hear from him. But there's so much to talk about today. It's our special Thanksgiving Day. It's actually the Tuesday before Thanksgiving. This is probably not going to actually be out until December. But we recorded this the Tuesday before. That's why the girls look great. We're going to have a little Friendsgiving. But who are you and what you doing here, co-host?
The firm's giving.
The firm's giving. The firm's always giving. That's like what we do.
Yeah, firm's giving. I am Queenie, aka the chef for today as well.
Yeah, where's your apron?
I made my apron. Zaina has my apron. It's in the kitchen somewhere, but I forgot about it. But I just took it off, so here I am in my sequins instead. But I'm Queenie, partner at Troutman Amin LLP, and co-host with the Czar.
Sometimes known as Pooja Amin. Also, I'll just go ahead and spell the name. The lady on the cover of Deserve to Win magazine, which you all love. But you made a turkey for today. I'm looking forward to eating. I'm literally going to eat the turkey that Pooja made. We're going to find out if it's good. But who are you, person that's talking about turkeys?
Hi guys, my name is Brittany Andres. I'm an associate attorney at Troutman Amin and the Baroness of TCPA World.
Yes, you are. It's great to have you. And last but not least, my blonde, who I'm getting used to having a blonde. I miss having a redhead. By the way, if you are a redheaded lawyer out there, we are hiring. Go ahead.
Hi, my name is Tori Guidry. I'm also the Dame of TCPA World and an associate at Troutman Amin.
It's wonderful to have you, Dame. So much to talk about. When we started this podcast, we were going to do it like monthly or weekly. We just do it when we want at this point. We've been so busy, but there's so much to cover because it's been a few weeks. Let's jump at a couple of things. First, really excited about a few developments. First, did you know that we already have had 50% more viewers on TCPA World in 2023 than we did in all of 2022.
Really?
Isn't that crazy? Because TCPA World was already like 50%? The hottest, best read TCPA blog, certainly, and one of the best read legal blogs on the planet last year. And this year, we've taken all the hits that we had last year, plus 50% more. The TCPA World is absolutely going off. Every time we do an article, we get thousands and thousands of hits. People are like really, really riveted because there's lots of cool storylines.
They just like the Dame and Baroness.
And they got the Real Associates of Orange County, just like blowing things up. By the way, girls, you're going to be on the cover of the next magazine, I understand, which is a pretty big deal. But no, look, the Real Associates of Orange County, the YouTube channel is doing great. We have more YouTube followers than Skadden Arps. Isn't that crazy? That's just bizarre. Isn't that just bizarre? But it's true. Like these big mega law firms, they don't have as many touch points or engagements as we do because people just love us. They love our content. They love what we have to offer. But of course, TCPA World remains, that huge gorilla, just massive legal blog that has so many folks engaging with it, so many folks reading. I just thought it was amazing. 50% more. But maybe it's not surprising. Because when we look at litigation, TCPA litigation, it's up 14% year over year from last year. There's this misperception out there that Facebook got rid of a bunch of claims. In fact, we'll have to ask Perrong how he feels about that. But instead of the TCPA cases going down, they're actually going up. And class litigation is constituting over 60% of the TCPA cases that are being filed right now. That is wild. Typically, under a statute, you see maybe 2, 3, 5% of cases that are being brought as a class action. The TCPA is more than 10 times more likely to be brought as a class action than other statutes. That is bizarre. And again, it just goes to show how aggressive the plaintiff's bar is. It remains the golden goose of the plaintiff's bar, right? More multimillionaire plaintiff's attorneys made under the TCPA than under any other federal statute. No wonder Andrew Perrong wants to be a lawyer now so that he can get some of that cashish. Pretty remarkable, really. So I want to talk about that. A couple other huge developments. My God, there's so much going on. PACE, remember Professional Associations of Consumer Engagement, the one-time rival of REACH, Responsible Enterprises Against Consumer Harassment. We were like the Jets and Sharks, or the Bloods and the Crips, or the people that don't like each other. What were the strawberry shortcakes and the blueberry muffins, whatever it is. Like they just didn't get along. What? That goes way back. They just didn't get along. But of course, REACH, the powerful organization that's led by the Czar and the Royal Court, of course, we have prevailed. Not that really we had anything to do with their collapse. They just collapsed. money mismanagement, as I understand it. I don't know. Like, I don't want to, I invited a couple people on the podcast to talk about it. They didn't want to come on. So I don't want to really, guess as to what happened, because truthfully, I don't know. What I do know is that, like, they just shut down suddenly out of left field about 2 months after pissing me off. Again, the two are probably not related. Probably not related, but in any event, Reach, though, remains strong and committed to advancing the interests of everyone in the direct-to-consumer marketing game and the lead generation world. Of course, the lead trade organization, speaking with all 5 commissioners of the FCC's office, along with the FTC, along with the Bureau, 6 separate meetings we've had with the commission over the last 2 months, trying to keep the lead generation industry alive, and so far it looks pretty promising all of a sudden. I think back at Lead Generation World, Contact.io back in September, before we started this big advocacy push, I was saying 70, 80, maybe even a 90% chance that this was going to go very poorly for industry. And now it's starting to look like maybe it's not so bleak. Maybe there's some daylight here. And I'm not going to lie, I think Reach's advocacy has everything to do with that. The industry by and large failed. They just flat failed to come to bat the way they should have and the way they needed to. Pace, of course, completely failed. They never even got out there once, and then the industry, that group just collapsed completely. But none of the other trades really did anything either. So it's just Reach. Like, it's literally just us. And even us acting alone, so much sway. But we have such a good story to tell, too. It's not like it's just us. It's not like, Eric's got juice. Maybe a little, but that's not really the issue. It's just that the story that we could tell was so captivating. Ultimately, we're on the right side of this. And when you're on the right side of something, it's really not that hard to sell the truth, right? You just walk in and say, hey, look, here's the facts. Can you please take a look at what you're considering and keep these facts in mind and do the right thing? And they're very smart people at the commission. Very, very smart, very knowledgeable, and beyond even intelligence and knowledge, they really are oriented to trying to do the right thing. And so I think we're going to get a positive result. We should know here in a little while. Hopefully I don't have bad news to report next year, but I think it's going to go okay. So that's my news. Was there anything else I was supposed to cover, Queenie? You have to keep me on task,
No. Well, there is a case, but we'll get to it. The ATDS Supreme Court case that I think you need to talk about a little bit. I think you had just mentioned you're curious as to Perrong's take on that issue in particular. So that was a great little article that you did that I think it's worth speaking about.
I talk about that right now.
Sure, go ahead.
So there was a recent appeal that was taken. So all of you know about the trim versus reward zone decision. That was the Ninth Circuit Court of Appeal opinion that decided that text messages, right, are not pre-recorded voice messages. Crazy important ruling, absolutely critical. The plaintiff's bar is actually taking that ruling on appeal, but not that part of the ruling, which is interesting. There was a second part of the ruling that looked at ATDS and held basically very simply that because of the Borden ruling for 2022, that an ATDS had to actually generate phone numbers in order to be an ATDS. That was baked into the trim ruling as well. Well, the plaintiff's bar, Adrian Bacon, who's been on our show before, has brought a cert petition to the U.S. Supreme Court asking the Supreme Court to address that issue, not the pre-recorded voice text message issue, the ATDS issue, to actually have the Supreme Court consider again what an ATDS is, and specifically whether or not, as the Supreme Court's already held, it has to, an ATDS has to use an ROSNG to either store or produce telephone numbers to be dialed. The Ninth Circuit formulation in Borden, of course, held that an ATDS must do only the use of an ROSNG to create telephone numbers to be dialed. Those are two different formulations. In my opinion, I'm already on record saying Borden got it wrong, because it did. Now the question is will the U.S. Supreme Court consider what Borden has done? Again, the Ninth Circuit. You'll remember, of course, Facebook was an appeal from a different Ninth Circuit ATDS ruling going completely the opposite direction. Wouldn't it be funny if the Supreme Court looks at two ATDS issues, both arising out of the Ninth Circuit Court of Appeal on the same statutory language with two rulings taking diametrically opposed positions? I think that would be delicious. But we don't know. We don't know yet. We'll see if that happens. But yeah, delicious. It's Thanksgiving, and I can smell the turkey, and so the word delicious came to mind. So Queenie, since you made the turkey, I'm actually looking at the turkey. It's right there. That's amazing. Hi, turkey. Queenie, what did you have for us?
So yeah, kind of piggyback on what you're talking about with the Ninth Circuit.
Pigs and blankets, right over there also.
So Ninth Circuit, the trim case that you were talking about, actually, that leads me into another important case that just came out related to the other component of the trim case, which was the SMS portion, where the Ninth Circuit ruled that SMSs cannot be pre-recorded calls under the TCPA because there's no audible component to it. The Ninth Circuit, though, however, left open whether MMS messages could be considered pre-recorded calls under the TCPA. So interesting. First in the nation case, yay, get excited, to address this issue out of Arizona in the Howard versus Republic National Committee matter. The court had ruled a few weeks ago that MMS messages are not pre-recorded calls because a consumer or the person receiving the text messages isn't obligated or doesn't have to listen to the audio component of it. Really, really interesting. Good news, for those sending out SMS text messages and especially those sending out political messages. That case came out of text messages with Ivanka Trump's voice encouraging folks to vote, and I think it's a pretty good ruling for the defense side. But I do caution it's the first ruling out there, right? With many of these other cases, first rulings that come out, you don't know how the different courts are going to rule, and then the trim case is, of course, still out there as well.
SMS and SMSs. Now, how is it different though? So in the Howard case, of course, the situation was the MMS was sent with the video format message. The consumer had to push the button to play, and the court said basically that was a conscious choice by the consumer to absorb the message, and therefore it wasn't the use of a pre-recorded call. But how is that different than a voicemail?
On the voicemail, that's a good question. I mean, the voicemail is similar, right? You don't have to necessarily listen to the voicemail. It's interesting, though, those sending out messages where, the MMS just plays automatically. I would caution that that's probably going to fall.
Is that a thing, though? Does that exist? Has everyone ever gotten an MMS message on their phone that's just like playing? Like, I just got a text message that's like, hello, this is Ivanka Trump. No. Like, you should vote. Oh,
probably not.
Never happened, right?
No.
So, again, I'm not trying to throw shit. The court did, because I respect the Honorable Judge Logan. I think his opinion was a good opinion, and frankly, we're going to leverage it. We're going to argue it's the correct ruling. But it is interesting because it suggests that there's a different kind of MMS message where the message plays itself, which I've never heard of such a thing. I don't
especially if you have your phone on silent. I just don't see how. I mean, the only thing that comes to mind are those alerts that pop up and you have no control over.
Those presidential alerts?
Yeah.
Those are the worst.
So we'll see, but really interesting case,
Okay. Well, there's an alert that turkey smells really good. Let's get to it. Tori, what'd you think? Any cases for us? Anything to talk about?
Yeah, I have one out of Colorado. It is the Klassen v. Solid Quote case.
That's a big one.
Yeah. So here the court modified the class definition at the outset of the pleading stage based on a motion to strike brought by Solid Quote. Solid Quote essentially said that the class definition, as it was, brought the case outside the permissible scope that was allowed by the statute, which only covers people who registered their own phone numbers on the DNC list. And the court, in its discretion, decided to modify the definition instead of granting the motion to strike. And they did so by just modifying it to only apply to those people that put their own phone number on the DNC list.
It's pretty interesting. I mean, it's interesting really in a couple of ways. First, it is hardly black letter law that you have to register your phone number on the DNC list on your own to begin with. Now, I think that's right. If you read the regs, I do believe that you do have to have yourself subscribed your number onto the DNC for you to have a private right of action under the DNC regs. I think that's correct. But that's not the majority view currently. So in this court's ruling, first it adopted the minority view implicitly. It didn't even explicitly find that you have to do this. It just kind of assumed that you did, right? And therefore found that second, that was an error in the class definition, essentially that the class definition was overly broad because it included individuals that did not have valid claims for this reason, right? Which again, may or may not be true, right? So that's fascinating enough. But then what the court does is rather than strike the class, which is what the defendant actually asked for, the court was like, nah, I'll just go ahead and make a minor, what am I doing? I'm rapping? That was weird hand language. Make a minor adjustment to the class definition which courts just never do on their own. And it just itself modified the class definition to remove individuals that had not put their own number on the DNC. Now, what if the plaintiff didn't put his own number on the DNC? The court just modified the class to exclude the named plaintiff. Isn't that weird? And as far as I can tell, I mean, that's not pleaded, so I don't know. I don't know the answer to that. I love this ruling. I think it's really fascinating. I love that the court was trying to kind of get to the punchline. May have jumped over a couple of hurdles to get there, but I really thought it was also interesting because the court basically said, look, we're not going to deal with this at the class notice phase. We're going to send class notice to everybody that's on the DNC list. Don't come whining to me about that defendant. But then the court basically said before a class member can opt in to the class, they have to first prove membership in the class by demonstrating that they did themselves subscribe. The problem is, of course, is that in America under Rule 23, there is no opt-in requirement. That doesn't happen. So the judge apparently misunderstood the application of Rule 23, or maybe just used some loose language, because maybe what the court was saying was in the post-judgment phase, in order to recover part of the claim, that you'd have to do like a self-identifying affidavit to opt in to actually recover the funds. Maybe that's what the court was saying, but that's not quite what the court said. Anyway, really fascinating ruling. Thank you for covering it. And that just leaves you, Baroness, standing between me and a turkey. What do you
I'll be quick.
No, take your time.
He said no.
Take your time.
So I have a new TCPA case. It's France Sampson versus United Healthcare Services, Inc. The defendant, United Healthcare, filed a motion to seal or redact 3 categories of documents. So the first being confidential and identifying information, including name, phone number, address, and medical information of class members. The second category of documents are documents pertaining to United Healthcare's internal policies and procedures. And the third category of documents were a list of United Healthcare's disposition codes for the calls. The court looks at whether there is a compelling reason to redact or seal these types of documents. So as to the first category of documents, the identifying information for the class members, the court found there was a compelling reason to redact this information because of privacy issues, obviously. As to the second category, the United Healthcare's internal policies and procedures, United Healthcare argued that if their competitors were able to get a hold of this information, they would replicate it and use it to their advantage. So the court found there was a compelling reason to redact the internal policies and procedures as well. But their analysis was a little different on the disposition codes because as to the last category, the United Healthcare argued that for the same reason as the second one, that the competitors would get a hold of this information, replicated it, and use it to their advantage. But the court found that there wasn't a compelling reason to do so.
Why not?
They didn't find a compelling reason because they couldn't determine whether or not, if the competitors got a hold of this information, that they could use that to their advantage.
So right before Thanksgiving dinner and before the Andrew Perrong interview, we talk about a redaction case. That's the worst case that we've ever talked about on Deserve to Win. That is the nerdiest, most esoteric case. What are the standards for redaction? All right, folks, well, thanks for bearing with us. It is indeed. And when you deliver it, everyone wants to hear about it, and I love you very much. Okay, folks, that's the time you've been waiting for. Through the power of the Troutman Amin firm, I'm incredibly excited, a little bit scared, incredibly excited to give you an interview with Andrew Perrong. And now, through the power of the Troutman Amin firm, I am delighted, although a little terrified, to bring you our exclusive interview with Andrew Perrong. Mr. Perrong, welcome to the show, sir.
Thank you. It's a pleasure to be on.
Now, I will start by saying you do not disappoint in terms of your devious appearance. You look every ounce the enemy of the state that folks here in TCPA world think of you as. So I guess congratulations on that. Give us a bit of your background, frame yourself however you'd like. But honestly, it's good to have you on the show. I think it's going to be a great discussion.
Absolutely. So, obviously, I think a lot of people know me from my previous work as both a pro se plaintiff and also as a class rep. And those cases really gave me the experience that I needed to, now as an attorney, advocate for the rights of consumers and really work for the public good, which is really what I'm striving to, start my practice off on as well. So I think that, obviously, my background is in tech. I ran my own computer services business before I went to law school. So that also gives me a unique skill set in these TCPA cases. And I'd be glad to talk about some of that as well.
So how many cases, before you decided to become a lawyer, how many cases have you brought as either a pro se TCPA litigant or as a class representative?
I think it's, it's obviously, a matter of record, but I think it's somewhere around 150 cases, both pro se and as a class rep or represented by counsel. But, like I say, that's given me a lot of experience to now bring those cases for other people.
All right. Now, in all those cases that you brought, though, I mean, like, how many of them did you put your name into a website or encourage somebody else to put your name or phone number into a website to set up the lawsuit versus how many were actual cold call solicitations that you had nothing to do with?
Every single one of them was a cold call solicitation. I mean, look, the concept of a fraudulent opt-in or, putting information into a website is quite frankly ridiculous. I get, on a good day, maybe 5 calls. On a bad day, I might get 25 to 30 calls a day. They're annoying, they're disruptive, they're incredibly frustrating. And I think that that's a problem that's shared with my clients as well. And, I'm willing to take those cases where there's allegations of lead generation fraud. And I think my technical ability gives me a lot of the skills necessary to be able to disprove those on a class-wide basis. And quite frankly, it's the elephant in the room nobody wants to talk about because it's one of the biggest issues, I think, in TCPA litigation. But it's the most underreported and the most misunderstood by both defense attorneys and by courts in the bar. Because, as you and I well know, lead generators only will pay for each lead that they generate. They get paid per lead. So it's in their interest to generate as many leads as possible. And then they just bury these leads to the point where innocent consumers are just getting calls out of the blue because of these, web forms through click farms, usually overseas. And from what I've seen in my litigation, both represented and even now, just as I'm getting started as an attorney, sellers are the ones that are holding the bag and, that are using false leads. When they get their hands stuck in the cookie jar, they default to this, we don't know what happened. We got this lead from somewhere. And then they call the lead gen stops answering their calls, or, the lead gen says, oh, let me talk to my data broker, that says, let me talk to my website owner. And I think that's an underappreciated risk that sellers face doing business with shady people is, with some of this lead fraud, they're going to be the ones stuck holding the bag at the end of the day. They're the ones responsible for a lot of these illegal calls that consumers are getting.
Andrew, let me ask, though. I mean, look, there's a lot of litigators out there, and none of them are held in high regard by the folks in industry, of course. But for some reason, you in particular just really drive people crazy. Do you have a sense as to why that is?
I think it's a false premise, honestly. I don't think that I'm only Mr. Evil, as you say, if people want to see me that way. And I think that myself and all the pro se plaintiffs that I've come across, that I'm now representing and I hope to represent, we're righteous, idealistic. We're doing this for the public good. And we're determined. We're just average people that are fed up with these illegal robocalls and this robocall conduct. And I think that pro ses in general just get mischaracterized and it's a bad rap in the legal community. And I want that to change. And I hope that will change by bringing these cases for others and, ultimately vindicating the rights of consumers. Because even in law school and whatnot, they say, pro ses are sometimes crazy. You have to deal with them. They don't understand the law. And in my experience, that's been a complete opposite of what I've seen. All of my clients that have also filed pro se cases are extremely smart, determined, and ethical, and very dedicated to the public good. So I think that it's really only a misperception that needs to change, and it's a misperception that people fall into, perhaps unjustly.
All right. Well, I don't want to beat you up too much, but maybe just a little. I mean, look, at least one federal court has found that you engaged in, quote, gamesmanship of the lowest order, which, I mean, that's really strong words from a federal judge. Look, I've been practicing law for 20 years. I've never had a judge say anything like that about me. And, you know, you hadn't even started practicing law yet. And as a pro se, you had to absorb a lump, which is very sizable. So I've just got to ask you, I mean, like, what happened in that case? Have you looked at your own behavior as a pro se and thought, you know what, I'm going to clean some of this up? Maybe you thought that judge was wrong that day. I don't know. I'm throwing it out there because now that you've become a member of the bar, I'm going to treat you with respect because you're an attorney. You deserve that. But by the same token, you know, I am concerned that you're going to be maybe carrying some perhaps bad habits that you might have had before you passed the bar in with you into the practice. And I'm going to tell you, it's not going to serve you well if you're going to be engaged in that kind of conduct. But I wanted to give you an opportunity to talk about it and not just, you know, talk about you behind your back. I'd rather do it directly to your face if I can.
Yeah, I mean, look, TCPA litigation can be contentious. There's some very confrontational issues there. And I think on my part, it was a little bit of youthful exuberance. The judge obviously pointed that I screwed up, pointed that out to me. And, you know, I've took the judge's concern to heart. I want to continuously improve myself, and especially in practice. And, you know, obviously I'm still going to advocate for my clients and hold them, you know, up. And, you know, obviously we're getting these clients up as class representatives. So we need to meet the requirements of the rules to bring them up as class representatives. And I hope to make a better impression, not with just with this judge, but with any judge the next time around, especially, as you mentioned, as an attorney.
I think that's well said, and I will say you may have already noticed this. You know, a couple of folks that took issue with me, you know, covering you becoming an attorney or having you on the podcast, and I told them directly, and I think it's just the truth. You're an attorney now, right? What came before, right? That was prelude. Now, from my opinion, that slate has been wiped clean, and I'm going to judge you based upon how you behave as an attorney moving forward, and I would encourage others to do that as well. And I will say, this is going to be strange, but I think the fact that you are working with the Wolf, with Anthony Perrong, is actually a good thing for you, because although I would stop short of calling him a gentleman attorney, which of course the Czar is, I have found him to be a fairly classy guy, or at least in one respect, he keeps his word, and that's important. And hopefully, you know, you've gotten a sense already that when you come into this world, you know, being able to deal, I was going to say man to man, but just person to person, and you know, being able to commit to something, keep your word, and know that when you say something, you're going to see it through. That's very valuable in this game, and hopefully you've started to kind of see that. But you know, if you wouldn't mind sharing kind of what your philosophy is, kind of coming into the practice of law, less in terms of zealously advocating for your clients, which I know you're going to do, but more in terms of how you hope to deal with the other side.
Look, you know, I'm always willing to work with the other side, you know, constructively to make a resolution. You know, obviously I realize that these are sometimes very contentious cases. They're cases that involve a lot of money, especially when they're run as class actions. But ultimately, you know, I want to talk to them productively. I want to help them understand in, you know, plain English, especially when there's these technical issues involved, especially with some of these, like I say, fraudulent leads that are being generated. Some other technical issues that come up in TCPA litigation. Just talk to them as a person, and really talk to them in plain English and help them understand where we're coming from our client's perspective, and from the perspective of consumer advocacy, and really why we feel that we actually have meritorious claims, and why the conduct that we're alleging violated the law.
A lot of times you come across in the past, I think, as angry. In this interview so far, you don't really have any anger. You seem kind of calm, you seem cool, you seem collected. Do you think that, like, now that you're an attorney, you can be a little bit more dispassionate and you're going to kind of move forward in this nice, calm, rational demeanor that you've got here? I think this is productive. There's a couple other pro se litigators I'm thinking off the top of my head that I'm going to, like, make sure you watch this video, because this is how you get respect from the defense bar and ultimately from the courts.
I think so. I don't know why there's this perception that I come across as angry. Again, I think part of it is just this perception of pro ses being sort of crazy. Like no attorneys want to take their case, and they're forced to file pro se. And in my experience, that's not even been the case. It's been the case that sometimes, the dollar amounts are not as high. The attorneys, they might not want to hire an attorney. And obviously that's everybody's right in the legal system. And I think that, obviously that's somewhat of a bad rap that pro ses get is, they're angry, they're crazy or something like that. And in my experience, that's just not been the case. And, I can't really think of why there would be that perception. I think that perception is what people make of it. And I hope that through this interview and through, going forward and the cases that I bring, that'll certainly be shown to be a mischaracterization.
All right, fair enough. Now, before we move into the future, I want to talk about the past, because you did mention you've got a technical background. You wanted to share a little bit about that and how you think it could help you to assist consumers moving forward.
Absolutely. So my background's in managed IT services. So I had a business that was the help desk for companies that were too small to hire a dedicated help desk or a dedicated staff to help them with their tech support needs. So I did managed IT all through college and all through law school. And I think that really that's given me experience in two key aspects. Like we already mentioned in lead generation fraud, because I can have that, I have those skills needed to be able to disprove lead generation fraud on a class-wide basis. The second thing I think that my technical background really will play well into is the issue of an ATDS. As I'm sure you're aware now, it's going up to the Supreme Court. We'll see whether or not the Supreme Court grants cert on some of these latest cases of ATDS usage. And I think it's really a matter of explaining to courts how certain dialing systems are capable of storing and producing random numbers without randomly generating telephone numbers themselves. And in so doing, actually meet the statutory definition of an ATDS under the statute. It's a delicate balancing act, I think, between getting the technical side right and also getting the legal side right, and being able to explain the technical side in a way that makes sense to judges and to courts in very plain English. And my experience is, essentially working for the help desk for some of these companies where, people aren't as tech savvy. You've just got office workers, but also, CEOs and whatnot. Just being able to explain the technical issues to them in a way that makes sense to the average person. I really think I can bring that into the courtroom and be able to explain that to a judge and say, hey, this is why our position's correct. This is why we think this lead was fraudulently generated. This is why we think that the defendant used an ATDS. So I think those are the two key places of where my technical expertise is going to serve me well.
Interesting.
Before we pivot off into kind of your future aspirations, how much have you made as a pro se litigant or as a professional litigant, or not professional litigant, that's not fair, as a class representative in TCPA cases?
Well, I don't know exactly how much I've made individually, but obviously in my two class cases that were certified and actually got class recoveries, that was $9.35 million in recovery for the entire class. So obviously as a class rep, I got, a $5,000 incentive award in one of those cases.
Right. Yeah, and now you saw your lawyers make millions off of those cases, and you thought, hey, I want some of that, right? And that makes sense. I respect that.
I think, obviously, I want to make a better living for myself, obviously, but it's not about the money. It's about vindicating the rights of consumers, and it's about getting consumers their statutory recovery that they're entitled to under the law.
But in seriousness, though, did it piss you off when you got like $5,000 and your lawyers got like $3 million? Did that bother you at all? Look, I'll be honest. If I was the class rep, I would have been pissed.
Not at all, because honestly, like I said, at the end of the day, it's not about the money. It's about my rights as a consumer, and it's about getting these calls to stop.
Okay. Well, so now you're on the other side. Now you're the lawyer. You're actually teaming up with Perrong on at least one class action. But I'm really curious. Like, can you share with us, like, how many cases have you filed? I've only picked up 2 so far. There might have been more. How many cases have you filed? Like, what kind of class litigation are you looking for? What jurisdictions are you looking for? Like, give people a sense of kind of what they can expect from Andrew Perrong in the immediate future.
Right. So I think I'm up to about 5 cases that I filed so far, both with Anthony, and some cases have been filed pro hoc vices pending and things like that. And I've got clients, obviously, that I'm still pending on and waiting on drafting complaints and whatnot. So you're going to be seeing, as we go into the holiday season, you're going to be seeing a few more cases come down the line. I think there's 3 key differentiators in the types of cases that I'm going to bring as opposed to other attorneys. And the first is, obviously, as I'm starting out, I'm going to be partnering with experienced counsel, not just Anthony, but with other, people on your top 10 list and what have you. But I'm also willing to take more larger individual type cases and file them individually. Class cases against defendants that might be a little smaller, might not be as, other attorneys might not be as willing to take. Second type of case that I'm willing to take, and as I've said, is those cases where there's allegations of lead generation fraud. I think that those are very powerful cases, and they're extremely compelling to a judge and jury once you actually disprove the lead and show how this was a pattern of fraud perpetrated on somebody's part, either a company or a lead generator. And the third type of case that I'm willing to take, that I haven't seen very many attorneys willing to take because of the uncertainty involved in it, are those ATDS cases. And I'm looking to file ATDS cases, and we'll see. We've got cases. I have my own case in the Third Circuit that's currently pending for ATDS, and we'll see how that shakes out, whether or not the Supreme Court grants cert. And hopefully we'll get some good case law on ATDS as well.
Interesting. Well, that last one is news, because, as you know, the plaintiffs' bar, by and large, has given up on this. I mean, you've got Adrian Bacon up there, flying his flag, trying to carry it for the bar. But as we look at the TCPA filings, we know, it's one of the things we talked about earlier in the podcast, that TCPA filings this year are up 13% from last year. And that's true, although the ATDS filings are almost zero. I mean, basically it's just the pro pers that are filing the ATDS cases right now. None of the big boys are touching that stuff. So it's interesting to hear that that's something that you're really going to hang your hat on.
Yeah, absolutely, and I think it's an untapped opportunity, especially because a lot of like you mentioned, a lot of firms are getting cold feet. They don't see, they're not willing to take the risk until they get more certainty from the courts, and I'm willing to take that risk.
Andrew Perrong and untapped opportunity. Those are 2 words I don't want to hear together, but here we go. Pooja, you have any questions for Andrew? I feel like I'm just hogging this.
Where'd you go to law school?
Temple University Law in Philly.
In Philly.
That's an actual real-life law school.
And then you just passed the bar, is that correct?
Yes, just passed the bar in July.
I don't know why I was expecting it to be like Gus's night school on the upstairs in Dominica or something.
So are you only barred in Philly currently then?
Only barred in Pennsylvania, but I do have, I'm admitted in a handful of federal courts as well.
Got it. Okay. Do you plan on taking the bar anywhere else? I guess it doesn't matter since you're sticking to TCPA. Are you going to dabble into any other type of work other than TCPA?
Well, I think I'm going to hang my hat on TCPA now, but definitely looking at other consumer issues, other class actions, and things of that nature as well. So.
And your thoughts on the mini TCPA cases that are going out?
Well, mini TCPA is very interesting. In Pennsylvania, we have a mini TCPA that's also in a state of limbo, based on some decisions whether or not there's actually a private right of action or not. The statute seems to indicate there is, but some courts have swung both ways on that, so hasn't really been a lot of clarity on that. But a lot of the mini TCPAs are in states where I'm not practicing. I don't really have very many clients, but obviously I'm always willing to partner up with somebody or bring those cases as they present themselves.
And now, I mean, I guess it's fascinating because now that you're a lawyer, I mean, you really plan to be doing the legal work, right? Because before, I guess when you were a pro per, you were filing cases, you were filing briefs, but then you were also working with lawyers as a class representative where they would be doing the work. So do you see yourself, I guess at this stage in your young career, you would see yourself as like the worker who's doing the work as opposed to bringing in the clients when you're partnering? Or kind of what's your role, I guess, as you bring in these cases?
I'll be honest, I shine in briefs. And that's where most of my work is going to be, in the briefing and in the oral argument. And even in some of my cases, both pro se and obviously represented by counsel. I've written a good portion of some of those briefs, and obviously had the attorneys review them and file them. But I've put my mark on them as well. So. I think I'm very experienced in that regard with, brief writing and oral argument, and that's where I plan to do most of my work.
Since you're in Pennsylvania, the other big, litigator in Pennsylvania is Shelton. Do you guys know each other? Do you have like an opinion on that guy?
Yes, we know each other. We're actually quite good friends, but obviously we have a good professional working relationship. I filed a case for him. I don't believe it was actually my first case, but it was one of the first cases that I filed. Was Shelton versus Whitebridge. So always happy to take cases from him or really anybody, and make good friends in the process, because ultimately my clients aren't just clients; they're also very good friends of mine. They're very good people that I like to speak to, and even just have a good professional relationship with, even outside of litigation.
Interesting.
I mean, Shelton, it's just something about you Philly guys or your Pennsylvania guys, because I mean, if there's one other person that drives people crazier than Perrong, it's Shelton, right? I don't know why.
I can name one other.
Can you? Because you got like Jacobson out there, you've got Diana May, but she's just different. She's like she's legend. I mean, who else is there
From a class perspective, yes.
Oh, I know who you're thinking.
You know who I'm talking
I'm not even going to name that person. You're right. There is one other person that drives us even crazier. All right, look, Andrew, you've been very, very fair. I think it's been a good interview, and you've been pretty good at answering our questions. So I appreciate that. Anything that you want to say, to the TCPA world faithful, recognizing that at least 3/4 of the people listening to this are spitting on my name, saying, "Why are you bringing Perrong onto this podcast?" But I like people to hear both sides of things. I like people to be able to look in the eye of an opponent and see, look, it's just a human being. Andrew Perrong, he's just a guy. He's a person. Now he's a lawyer, so we're going to treat him with respect, and we're going to see how it goes. But do you have any thoughts, anything you want to share with folks?
Well, I appreciate it because, I understand, obviously you've gotten some pushback from and controversy for having me on. And I've, even from my side, have had some people saying, don't go on the podcast either. So I certainly appreciate, I do agree. It's been a wonderful time. It's been very productive, and I appreciate your cordial nature and everything like that. Ultimately, I think you're going to see a lot of me in the future. You're, like I say, you're going to see a lot of me, but ultimately it's going to be about vindicating the rights of consumers. It's going to be about bringing these cases to a conclusion that's amicable for both parties. Both my clients and the defense. An attorney, I hope to be professional and have a good relationship with everybody that I come across. And I make that commitment to you, and I hope that this podcast shows that. So ultimately, that's all I have to say.
Well, I will say this, and everyone knows this about me, is that, look, if you come on the podcast, you kiss the ring, then I like you. Then I'll treat you with respect. I mean, it's just true. I'm very simple. What I was going to ask, though, in all seriousness, is you have to tell me what it is, but is there a book on Eric Troutman and how to deal with him on the plaintiff's side? I mean, is it like widely circulated, like some bullet points, like here's how you deal with the Czar? Again, you don't have to tell me what they are. I just want to know if because I've heard that there was.
I have not heard of one, so
okay.
I think you're in the clear on that one.
Well, that's actually deflating for my ego. I'm actually bummed. That actually bums me out. I was fully expecting a yes on that, which is just too bad. But all right, well, fair enough. Well, look, Andrew, it's been great to have you on the show. I guess I'll ask you one more question because, of course, the name of the podcast is Deserve to Win, and we always like to ask our guests, and you can frame this however you want. Usually, we ask you to look at it through the lens of like people that are call center operators or lead generators or sellers. Folks, how can they deserve to win? If you want to answer it to the frame of, what a consumer advocate like you can do to deserve to win, or anything else, just, the phrase "deserve to win." What can people do to deserve to win, in your opinion?
Well, I think on the defense side, on your side, to deserve to win, you really need to show that you are taking compliance seriously, that you are policing your vendors, that you're not using these fraudulent leads, that you're doing everything in your power to make sure that you are only getting signed written consent that you have verified that is legitimate, and you're not calling people that don't want to be called. And on the plaintiff side, I think to deserve to win, it's all about doing the public good. It's all about doing a civic duty and being good, honest people that are just fed up with these calls and want them to stop, and really making that argument to a court and showing, look, these are just average people, just like the judge gets 5, 10, 20 calls a day, and we just want them to stop. And ultimately, just vindicating your own rights and being able to advocate for yourself and show how these calls, how you identified these calls and want them to stop and how they didn't stop, that's ultimately how to win on the plaintiff side.
Okay. Well, look, again, I respect you coming on the show. I wish you the best in your professional career. I'm not going to give you a round of applause for political reasons. I don't think that'll be well received by many. But I do look forward to working with you, hopefully productively, as we both continue to strive to uphold the highest standards of professionalism in this industry and in our profession, which I take very seriously, as everyone that watches this knows. And I hope that you will as well. And again, so long as you do, whatever came before is prelude, and I'll respect you as a fellow counselor of the bar, and I do wish you success. Not against any of my clients, stay away from them. But in your other pursuits, I do wish you well. So thanks for being on the show, Andrew.
Likewise, thanks a lot. Thanks for having me.
Wow. Well, that was fascinating. It started off going one direction, and then kind of ended up a different direction. I'm a little uneasy from that interview. I'm going to be honest with you. That was the first time I left, and it was I don't know. I'm a little bit conflicted, and I'm not totally sure what I just saw. My mind is still spinning a little bit. So I want to tell you what, I'm going to absorb some of your thoughts. I know, Pooja, you're always a lot more decisive and judgmental, dare I say, than I. What did you think?
Well, I'm judgmental to pro se plaintiffs, as you know. Well, I guess one word to start off, I think he's a complete knucklehead. Knucklehead comes to mind. And it's so interesting to me that the wolf, Perrong, is working with Andrew Perrong. For those who don't know, Anthony Perrong has a high level of respect for the Czar and for the Queenie over the years. He's built, respect for us, dare I say. And Perrong also judges the defense bar as much as we judge the plaintiff's bar. So to me, it was quite shocking, if you're listening to this, Perrong, that you have onboarded such a knucklehead to be, by your side, because I'm curious to see what kind of cases he's going to bring. I'm curious to see what kind of ATDS claims he's going to bring before the Supreme Court has even had a chance to review it. The plaintiff's bar, as we've said, before, a few of them, they're intelligent folks, right? They're bringing these cases. They're fighting against the Czar and the Queenie and the entire Troutman firm, but they're putting up fights, right? Because they're, not as equally as intelligent as us, but they have some intelligence to them. Andrew Perrong, I just don't know. I don't know if I can value his worth as an attorney just yet. But
he's a baby. He just started.
I understood, but when he was talking about briefing, I was kind of holding back a little bit of chuckles. But to me, what was really interesting was when he went through the 3 types of cases, as he, said, I am willing to take, and he listed out 3 different cases he's willing to take. I was waiting for him to say, I'm willing to take cases where the consumer is harmed, where I really, truly believe that the consumer has some harm that needs to be corrected. When Eric and I onboard clients, one thing we always look for is, are these scumbag companies, right? Are these good actors willing to do the right thing, that take compliance seriously, and they just got hit with an unfortunate, TCPA class litigation. They're really trying to fix their operations. We take on clients that want to do the right thing. So I was really hoping he would say that, because I would have had a little bit more respect for him, but that never came out of his mouth. So those are my thoughts.
No, it's a lot of good thoughts. Actually, that last point is actually a good one. The plaintiff's bar knows, like, I'm famous when I get a new case potentially in, I will call the lawyer on the other side and be like, hey, look, I'm thinking about coming into this case. Are they a scumbag, right? Like, because I don't want to represent scumbags. I have no interest in representing scumbags. And if I've got a scumbag client, I kind of want to know that. We like to bring in clients who really want to comply with the law, who will take our advice, who will improve. And then, if they get hit in a suit, it's usually because of something beyond their control, and then we are happy and pleasure. It's an honor to defend these people because they are good companies that want to do things the right way. But you're right, kind of from the inverse. But I don't want to be too hasty with him, and because, look, he just passed the bar. Remember where you were when you just passed the bar?
That's great.
Remember where we all were?
I came out of the womb ready to go.
Well, in fairness, so did I. But that's pretty unusual. Not everybody does, All right, what did you think, Brittany?
So, I know this is a matter of public record that we had a case against Perrong last year, and it was a very interesting case, and I know that we have strong feelings against him. I didn't have an image in my head and how he looked like, but seeing him for the first time, I was completely shocked. I don't know why. Maybe it was just different than what I expected. But you're right, Pooja, it's interesting when he mentioned the 3 cases that he was looking to bring, especially the ATDS cases, because I know the plaintiff's bar have been slow or just not really picking up those cases anymore. So I guess now that he's passed the bar, we'll see in the future what we encounter with him.
Was he younger than you expected? He was younger. He looked a lot younger. I didn't realize he was a baby.
I knew that he was young because I did a little research on him when we were dealing with him last year, and I wanted to know what we were getting ourselves into, and so interesting.
Yeah, well, I will say, since we're focusing on appearance, when I first saw him, I was kind of like, you've got to be kidding me, right? Like, this isn't really what he looks like, because he kind of has that, menacing, the eyebrows are almost kind of together, and like in the beginning at least, he had that like smirk he just couldn't hide, where he just enjoys the mischievousness of his non-redemptive activity. But by the end, he started to realize that this is a grown-up profession, right? And we all have to grow up. Even someone like the Czar, who has, very obvious. I'm a kid at heart, and I always will be, from a certain perspective. But from the other perspective, this is a profession, and you do need to govern yourself accordingly. And that's why I hit him very early on with that finding from the court that he had engaged in that gamesmanship, because that's not the sort of thing that we do around here. TCPA litigation is incredibly complex, as he pointed out repeatedly, and I think tellingly. There's a lot of money involved here, right, on the plaintiff side. If you want to live in this world where ultimately, someone like me, the Czar, how many clients do we have, right? If a guy like Perrong wants to eat, well, he better recognize that if we tell all of our clients to never settle a dollar for that guy, he's got no career, he's got no path forward. And again, I don't want you to think that there's like collusiveness between the plaintiff's bar and the defense bar, because there isn't, but there is this recognition that if you are going to come out as a plaintiff's lawyer and be disrespectful to people and treat people poorly, you're not going to be successful. You're just not. And the truth is the same for the defense bar, right? The defense lawyers sometimes, I think, fall into the habit of being incredibly and unnecessarily combative. But really, that will never get you as far as staking out a reasonable position, saying, this is my position, and meeting it, period, the end. And I think, fortunately or unfortunately, in the plaintiff's bar, I'm surprised he didn't say there was a book. I've heard there's a book on me.
There's a blog count, like Facebook.
And the book is simply that, if I say something, I'm going to take it to the Supreme Court, right? Like, if I don't say something unless I mean it. And if you can recognize that, then you can just accept that what I have spoken, that's how it's going to be, and then we can get to middle ground, just with whatever that one little thing, because usually it's just one little thing that I require before we get to a decent resolution. And those that won't give the Czar his due, it doesn't go so well for them for the most part. But we're supposed to be talking about Perrong. Of course, I make it all about me. What a surprise! How dare you enjoy that so much, Tori? What did you think?
Well, I thought today at least he came off very polite and well-spoken, although that is not what the reputation that precedes him, gives off. So I'm hoping that he can keep this demeanor throughout his law career, and if this is how he's starting as a young attorney, then that's likely a good sign. But I have a question for you. Are you going to give him a nickname?
No.
Okay.
Well,
he definitely doesn't make Queenie's top 10, let me tell you.
No, I mean, look, it's premature. I mean, I'll put it this way. One of the things I took away, now that we're kind of getting to my takeaways here, is he wants to be in this game for a long time, right? Like, he wants to demonstrate staying power. He came on this podcast to send a message, right? He's putting down his flag and he's saying, TCPA world, this is my home. I'm going to live here. Get ready because you're going to be seeing a lot of me, right? I respect that, right? The guy he's pointing to the left field bleachers and he's stepping in the batter's box saying, that's where I'm going to hit it. And, I respect it. We'll see how he does, because as I've said many times, this is not a world for people that don't know what they're doing. Now, he's got some experience. He's shown some longevity before he became an attorney. So, part of me says this guy might be successful here, but he wants to have a reputation in this world. He wants to be here for the long term. So, if he is successful, I'm not going to rule out that he gets a nickname one day. I don't think it's going to be a very nice nickname, but he doesn't get one yet. He's not there yet. He's just, Andrew Perrong for now, but that could change. And so as I kind of wrap this up here, I will say the jury is out on Andrew Perrong, but I don't think anyone should rush to judgment. As you heard me say a couple of times, look, what came before you're an attorney, you're not, in my opinion, you're just not fully grown up yet, right? You're a pro se litigant. You're kind of goofing off out there, seeing what you can do. And you saw this guy. He's got that little mischievous streak to him, right? He was just trying to see what he could get away with. I get it. Now you're an attorney. Now you've passed the bar. You've taken an oath. And you've got rules of professional responsibility that govern you and ethical considerations. Once you kind of pass through that, metaphysical and literal bar, you now have to hold yourself to higher standards. And I welcome him as a new member of our profession. And if he can demonstrate that he can hold himself to those professional standards, then he will have my respect, even though we're on the opposite side of the V. Those of you that watch my podcast know I hold people on the other side, I hold them in high regard. In fact, some of those folks I hold in extremely high regard. People like Abbas Kazarunian, who I just think are just brilliant lawyers, and Jay Edelson, just brilliant lawyers, even though philosophically we do not align. But they're also highly ethical attorneys, people who are real, true professionals and who hold themselves and others to the highest standard. And I would encourage Mr. Perrong to do the same thing. And if he does, he'll always have the czar's respect, even if he's bringing cases that I wouldn't otherwise want to touch with a 10-foot pole. And for the rest of you that tuned in, look, we love all of you. I know it's hard for you to stomach sometimes seeing a guy like Perrong, but please just try to understand that this show is about perspective, right? It's about teaching people how to win and how to learn from one another how to win. And really, as we talked about a million times, like one of my big philosophical issues with the world that we live in today is that everyone is so captured in their own little echo chamber where they only hear opinions that they want to hear, they only hear from the news that they want to hear, and they can't trust, believe, see, understand anything other than their own perspective, and it's terrible. It's terrible. And so TCPA world will be a little tiny sliver of society where those rules don't apply, and you have to hear from people that you don't necessarily want to hear from, because guess what? You're going to learn something, and I know you did. Really very grateful that all of you are here. Of course, Thanksgiving episode, gratitude, always gratitude. And we will see you next time. Thank you so much for tuning in to the 19th edition of the Deserve to Win podcast. Tune in next time for more truth, beauty, and telecom law. Bye, folks.